Thank you.
Home Secretary, you have repeatedly said that you would be breaking the law were you just to deport Qatada. How?
Well, in a number of ways, Mr. Reckless. I mean, first of all, the UK government abides by its international treaties, and we do not break those international treaties. That's why we abide by the Article 39, Rule 39, that was given by the European Court, which was an injunction on the deportation of Abu Qatada.
Can you confirm that that Rule 39 injunction has no effect in UK law?
What I can confirm is that this UK government operates according to the rule of law. It operates according to its international treaties. That is part of that. But there is a second part to my answer, if I may, if you're about to come back into it.
Before we go on to that, we could deal with this international law point, because there is concern that you may be putting an intergovernmental agreement with the Council of Europe before the law of the land is determined by Parliament and our highest court. And you told Parliament that our highest court, then the House of Lords, now of course the Supreme Court, had said that Qatada should be deported. Given that, why are you putting this intergovernmental agreement before the law of the land?
Well, I'm not, and if I can explain the stages which mean that it is we act in accordance with international law. We're absolutely clear. This is a Rule 39. If we were to break that, it would be contrary to international law. Our public policy when dealing with deportations is to respect Rule 39. We make that absolutely clear in public guidance, and we have said that to the court. So our courts are clear that the law requires us to act in accordance with our published guidance and apply such guidance consistently. And that is also clear, and if we were to break that, we could be judicially reviewed on that. But the other point is a very simple one, Mr. Reckless, which is, if we were to move it, if we were to set that aside, if we were to say, as I know you believe, that we should say, well, this is a rule from the International Court and therefore we don't accept it. If we were to say that, we have to give 72 hours notice of deportation to an individual. I am very certain that the individual concerned would have sought, his lawyers would have sought an injunction against that deportation, that there would have been a point of law to be considered, notably whether it was possible for the UK government to act contrary to the Rule 39 injunction. And at that point, we would not have been breaking law as set out by the European Court, we would have been breaking in contempt of court here in the UK. And that's why there are various layers why I say that I believe that we should be acting within the rule of law. I know it's frustrating to people. I want to be able to see him deported. It takes time, but I'm also clear that we should abide by what we have said, that we abide by the international law and we abide by the Rule 39 injunction.
Home Secretary, I'm afraid you've missed a step there. I think it's clear that the Rule 39 injunction is not binding in UK law and is merely an international obligation, as you refer to it. But in terms of Qatada getting this domestic injunction, which would make his deportation unlawful, are you certain he would get that? Is that not merely speculation?
Well, I'm learning rapidly. I think I learned fairly rapidly in this role that one can never be certain about the decisions that judges take, and that's absolutely right, because it is for them to judge each case on their merits, and that is as true for the European Court and for the UK courts. But if I may, I was trying to set out the various stages at which it could have been the case that the UK government would have broken law. You dismissed the issue about our attitude to Rule 39. What is clear from our UK courts is that when we're deporting somebody, we should be doing it according to the guidance that we have issued, and it would have been possible for an injunction or a judicial review to follow on that, and also on just public law principles of fairness.
But the guidance is not law, and you have said that our highest court has said that Qatada should be deported. Is it not possible that if his lawyers resist that deportation, a domestic court will consider itself bound by our highest court and its previous decision that Qatada can be deported? Why do you not test that so we can get this man out of the country quickly?
Well, as I've tried to explain, it is not only the fact that an injunction, there could be a judicial review, there could also be an injunction. And the point about the injunction is, the question would be, would there be a point of law for the court to consider, as I understand it, and there would indeed be a point of law for the court to consider. And that's why I think that it would have been highly likely in those circumstances, and setting aside what I consider is the right thing for the UK government to do, which is to say we abide by the rule of law.
Good. Can we just close and conclude the Abu Qatada section, I know that Nicola Blackwood has a quick
by the law.
supplementary.
I'm reading here from the Ministerial Code of Conduct, which places a duty on ministers to comply with the law, including international law and treaty obligations. As I understand it, that would include Article 39 rulings, would it not?
Yes, it would.
So if you were to ignore that, you would be breaking the Ministerial Code of
Yes.
Conduct. Thank you. That was my only question.
Reckless wants the right of reply, I'm afraid I have to give it to him. I'm a very fair chairman. Yes, Mr. Reckless.
Can you confirm, Home Secretary, that the Ministerial Code is the responsibility of the Prime Minister, and that we have not previously had a Conservative Prime Minister who had in that code any reference to international law?
Well, I can confirm, obviously, that the Ministerial Code is the responsibility of the Prime Minister. I will be honest with you, Mr. Reckless, I have not read every Ministerial Code under every single Conservative Prime Minister that there has ever been.
Well, Home Secretary, I have.
Why not?
And I would ask you, do you agree with ex-Cabinet Secretary Lord Butler, who said that the Ministerial Code has no statutory force, is neither comprehensive nor absolute? Ministers are accountable to Parliament, not a piece of paper.
Of course ministers are accountable to Parliament, but I can assure you, Mr. Reckless, that if a minister broke the Ministerial Code, Parliament would have something to say about
That's
it.
a very good question, will you?
And more than one, potentially. On the 7th of November, Home Secretary, you said that senior officials at the head of the border organisation put at risk the security of our border. Our task now is to ensure that those responsible are punished. Have you now done that?
There's obviously, Chairman, you
A
would
one form of
appreciate
punishment, was it?
Well, there were disciplinary proceedings were put into place and a report was done in relation to individuals within the UK Border Force. Obviously, you would appreciate, and I cannot, there is a limit to what I can say in relation to this, but obviously you will appreciate that the then head of UK Border Force is no longer in the Home Office.
Can you confirm that his punishment extended to 6 figures?
I am not at liberty to make any comment about the arrangements that were made.
And John
And
Vine,
I'm not at liberty to do that because both sides agreed a confidentiality agreement.
Home Secretary, you've chosen to agree a confidentiality agreement with him rather than to answer for Parliament for the expenditure of public money. But John Vine, in his report, confirmed that Brodie Clark told you about suspending Secure ID in his weekly reports to you, but you did not read these. Can you explain why that was?
That is not what the Chief Inspector said within his report, Mr. Reckless.
4.106 is the paragraph. Why? You read the first 3 of his reports, but not the ones after that where he referred to the
you're
suspension
talking
of
about
Secure ID.
Perhaps, Chairman, I may look at the particular reference that the 4.3...
4.106.
4.106.
You said you'd cooperate with John Vine, but he says he was unable to establish why you didn't get these, and there was no clear explanation for the omission given to him. Why was that not done?
No, I'm sorry, Chairman. What he says was that he established that ministers only received the first 3 of 7 weekly update reports, whilst the acting chief executive received the first 4. We've been unable to establish why they did not receive the others, as there was no clear explanation for this omission. Those reports were not received, and if ministers don't receive the report, they can't read it.
Okay, so the first 3 of these were presumably in your red box. Why did the further reports, when he referred to the suspension of Secure ID, not go into your red box?
That is a question which has been asked, and I believe that there was some question as to whether the reports came to a position in the Home Office where they would be capable of being put in my red box, if I can put it like that.
You can find out who missed the deadline of the red box at some stage. Are we done?
Thank you.